Let us discuss the provision of Section 474. What Section 474 provides? Having possession of document described in Section 466 or 467, knowing it to be false and intending to use it as genuine. What is 466 and 467? You go through it. 466 says that forgery of records of court or of public register. 467, forgery of valuable security. What Section 474 says? Whoever has in his possession of a document or electronic record, a person who is in possession of a document or an electronic record, knowing the same to be forged, and intending that the same shall be fraudulently or dishonestly be used in genuine. A person knows that some document, that a particular document or particular electronic record is forged, and he possesses that document. What for? Intending that the same shall be fraudulently and dishonestly be used as genuine. Shall, if the document or records is one of the description mentioned in 466, that is for document of court or of public register. 467, that is forgery of valuable security. Then in such case, he be punished with imprisonment or either death for a term, which may extend to 7 years and shall be liable. And if the document is one of the description mentioned in 467, then shall be punished with imprisonment for life. Because forgery of valuable security or will, if a person is in possession of valuable security or will, what is valuable security? Valuable security is a document whereby any right is created, extended, extinguished, or that is a valuable security. So, or will. So, in such case, he shall be punished with imprisonment. If he knows that a particular will is a forged one, particular sale deed is a forged one, particular document is a forged one, that is valuable security is a forged one, and he possesses that document. But if we intending that the same shall be fraudulently, dishonestly used as genuine, then punishment is life imprisonment or with imprisonment either decision for a term which may extend to 7 years and shall also be liable to fine. 475, counterfeiting device or mark used for authenticating documents described in Section 467 or possessing counterfeit marked material. You know that some documents, wills, are some valuable security. Those are that is authenticated. When it is authenticated? When it is sealed by a particular officer. So if a person who possesses that counterfeit seal to make that document authenticated, that is a will or any valuable security, for that a separate punishment is there. Whoever counterfeits upon or in the substance of any material, any device or mark, any material, any seal, any mark, which is used for the purpose of authenticating a document. What is authenticating? Authenticating means certifying that document is a genuine document. Authenticating a document described in Section 467, that is will or valuable security, intending that such device or mark shall be used for the purpose of giving the appearance of authenticity. Intending that such seal, such material, if used, that will appear as the authenticity of a document, then forth or therefore to be forth on such material or with such intention as in his possession any material upon or any substance of which any such device or mark has been counterfeited, shall be punished with imprisonment for life or with imprisonment of either death or for a term which may extend 7 years or more. 477, fraudulent cancellation, destruction, etc. of will, authority to adopt or valuable security. What is authority to adopt? Through a document, if somebody authorizes another to adopt on his behalf, that is called authority to adopt. Fraudulent cancellation, fraudulent always with intention to defraud. What is defraud? If a concealing something, thereby if a person gets advantage. So fraudulent cancellation, if a fraudulently cancels any document, destroys any part of the document or will, even authority to adopt or valuable security, then that is a different type of punishment. Whoever fraudulently or dishonestly or with intent to cause damage or injury to the public, fraudulently or dishonestly, with intent to cause damage or injury to public or any person, cancels, destroys, defaces. What do you mean defaces? Suppose a particular thing is mentioned, that is defaced. So that, or attempt to cancel, destroy or deface, erase, or secrets, or attempt to secrete a document. Secrets means what? Somewhere conceals some document, or a document which is purport to will, or an authority to adopt, or adopt a son, or any valuable security, or commits mischief in respect of something. Mischief destroys, causes damage. That is mischief. Shall be punished with imprisonment for life or with imprisonment for either death or for a term which may extend to 7 years and shall also be liable to fine. 477 is a 7A is a very often used in it is this misappropriation case. That is by public servant or any servant when misappropriates somebody. For misappropriation, some false accounts are prepared. Some false accounts are prepared. That is called falsification of accounts. Section 477A provides falsification of accounts. Falsification of accounts means what? Suppose a person is maintaining an account. He mentioned something in the account, incorrect statement, making some false entry in the statement. That is called falsification account. So what is this? Whoever being a clerk, officer, or servant, or employed, or acting in the capacity of a clerk, officer, or three persons: clerk, officer, servant, or employed or acting or in the capacity of a clerk, officer, or servant, willfully and with intent to defraud, destroys, alters, mutilates, or falsifies. All the things, defrauds, or destroys, alters, mutilates, or falsifies any book, electronic record, paper, writing, valuable security, or account which belong to or in possession of his employer, makes false entry in the employer, destroys the accounts of the employer, or alters any entry in the affair, in the account of the employer, or has been received by him, or if he has received something, some document, there he makes any destruction, alteration, or for his on behalf of his employer, willfully, intendingly. Accidental mistake is not 477A, but willfully and with intent to defraud, makes or abets the making of any false entry. He himself does it, or abets the making of such false entry, or omits or alters, or abets the omission or alteration of any material particular from it. And such book, electronic record, paper, writing, this is false document, making false entry of by a clerk, servant, or an officer of the books or the accounts, records, electronic records of his employer, either by himself or by abetting by through somebody, shall be punished with imprisonment of either death or for a term which may extend to 7 years or with fine or with both. It shall be sufficient in any charge under this section to allege a general intent to defraud. So while framing charge, it will mention the general intent to defraud without naming any particular person intending to be defrauded, generally defrauded, or specifying any particular sum of money. Sometimes particular sum of money is not mentioned, intended to be the subject of the fraud or any particular day on which the offense was committed. That is 477A. 478. These are the of property and other marks. Because by passing of Trade and Mercantile Marks Act 1958, the section 478 was deleted, repealed. Property mark also, that is also repealed. That is particular person. This was deleted or repealed using a false trademark. That is also repealed. Only one section 481 using a false property mark. Whoever marks any movable property or goods or any case, package or other receptacle containing movable property or goods, or use any case, package or other receptacle having any mark thereon in a manner reasonably calculated to cause it to be believed that the property of the goods so marked or any property or goods contained in any such receptacles so marked belong to a person to whom they do not belong. Whoever puts a mark, the property mark, that it belongs to a person to which doesn't belong, is said to use a false property mark. What is using a false property mark? That has been defined in section 481. Whoever marks any movable property, there is a movable property, a mark is given. In movable property, some mark is given so that it is distinguishable. It is known that that property belongs to a particular person. For an example, you might have seen that a mark is there in certain property in the office. There it is mentioned, this is a particular office. So a particular person. But a person puts any property mark either in a movable property or a goods or any case, package or other receptacle containing movable property. Though in such there is a mark that it belongs to a particular person. Whoever puts a mark there and in a manner reasonably calculated to cause it to be believed that the property or goods so marked belongs to a receptacle so marked belong to a person to whom they do not belong. So is said to use a false property mark. Punishment for using false property mark. Whoever uses any false property mark, what is property mark? Any mark is given in a goods, receptacle, any case that it belongs to a particular person. Whoever puts a mark so that it is to believe that it belongs to another person. Then so in such case, it would be use of a false property mark. Punishment for using a false property mark. Whoever uses any false property mark shall, unless he proves that he acted without intent to defraud. A false property mark is put. Unless he proves that he has put that mark without intention of defraud, then in such case he will be punished with imprisonment by either for a term which makes him to 1 year or with fine or with both. Counterfeiting a property mark used by another. Similarly, counterfeiting, preparing a thing, property mark resembling the property mark of another. That is counterfeiting. Whoever counterfeit has been defined. Whoever makes anything to resemble another thing, that is counterfeit. Whoever counterfeits any property mark used by any other person shall be punished with imprisonment by either decision for a term which makes him to 2 years or with fine with both. 484. Counterfeiting a mark used by a public servant. Suppose a public servant uses a mark. Suppose who counterfeits a mark? Whoever counterfeits any property mark used by a public servant or any mark used by a public servant to denote that any property has been manufactured by a particular person or at a particular time or place, or that the property is of a particular quality, even called ISI mark is counterfeited. So this section 484 is applicable. Or as passed through a particular office, suppose custom mark is there, somebody counterfeit mark is used, so or it has been checked. So that is punishable. That is counterfeiting a mark used by a public servant that is same to be counterfeit shall be punished with imprisonment by either decision for a term which may extend to 3 years or with both. Making or possession of an instrument for counterfeiting a property mark. Similarly, simply possessing an instrument for making a counterfeit property mark, that is also punishable. Whoever makes or has in his possession any die, plate or other instrument for the purpose of counterfeiting a property mark. Die means a color. Or has in his possession a property mark for the purpose of denoting that any goods belong to a person to whom they do not belong, shall be punished with imprisonment either decision for a term which may extend to 3 years with fine or with both. 486. Selling goods marked with a counterfeit property mark. A counterfeit property mark, if a person who sells is also liable. Whoever sells or exposes or has in possession of sale any goods or things with a counterfeit property mark affixed to or impressed upon the same or to upon any case, package or other receptacle in which such goods are contained. Suppose a particular property mark. What is property mark? A mark that is signified that from that mark it is known that it belongs to a particular company, particular person. So if a false property, whoever sells or exposes, suppose Amul is there, or say for Mata, that is property mark. Sell goods marked with a counterfeit property mark. Whoever sells or exposes or has in his possession for sale any goods or things with a counterfeit property mark affixed to or impressed upon the same, or to upon any case, package, or other receptacle in which such goods are contained, shall, unless he proves that having taken all reasonable precautions, a person having taken all reasonable precautions would not know that a particular goods, particular quality, particular property, a particular company, committing an offence against this section. He had, at the time of commission of the alleged offence, no reason to suspect the genuine. He had no reason to suspect the genuineness of this good, or that on demand made by or on behalf of the prosecutor, he gave all the information in his power with respect to the person from whom he obtained such goods. When that is a demand is made by the prosecutor, he gave all information from which source he purchased, that otherwise he had acted innocently. If this is not true, then he will be punished with imprisonment for a term which makes him to 1 year or with fine. Making a false mark upon any receptacle containing goods. Similarly, whoever makes any false mark upon any case. What is false mark? That has been defined. As I told you before, 81, a false mark, using a false mark. So whoever makes any false mark upon any case, package, or other receptacle containing goods in a manner reasonably calculated to cause any public servant or any other person to believe that such receptacle contains goods which does not contain, or that it does not contain good in which it does contain, or that the goods contained in such receptacle are of a nature or quality different quality. Suppose Amul ghee, Amul butter, but it is this is applicable. This is false mark is put in a goods receptacle package that it is of a particular make, particular property. Shall, unless he proves that he had acted without intention or defraud, be punished with imprisonment either duration for a term which makes him 3 years suitable. Punishment for making use of any such false mark. Whoever makes use of any such false mark, whoever makes use of any such false mark in any manner prohibited by the last foregoing section, shall, unless he proves that he acted without intent to defraud, be punished as if he had committed an offence against that section. So that is, then tampering with property mark with intent to cause injury. Similarly, whoever removes a property mark is removed, destroys or defaces or adds to any property mark, intending or knowing it to be likely that he may thereby cause injury to any person shall be punished with imprisonment either for a term which makes him to 1 year or each both. Then this section 489A, that is of currency notes and banknotes. These are the offences of currency notes and banknotes. These are very serious offences. Counterfeiting currency notes or banknotes. What is counterfeit? Counterfeit, it has been defined in which section? That is probably section 25. What is counterfeit? A person is said to counterfeit who causes one thing to resemble another thing. Who causes one thing to resemble another thing, intending by means of that resemblance to practice deception. First thing, who makes one thing to resemble another thing, intending that by such resemblance he will practice deception, or knowing it to be likely that deception will thereby be practiced. This is counterfeit. If somebody puts a question, what is counterfeit? Who makes, a person is said to counterfeit who causes one thing to resemble another thing. A person, you always remember it. What is counterfeit? A person is said to counterfeit who causes, not makes, who causes one thing to resemble another thing, intending by means of that resemblance. Who causes one thing to resemble another thing, intending that by such resemblance he will practice deception, or deception may be practiced, or that is likely that deception will thereby practice. It is not essential to counterfeit that the imitation should be exact. It is not, explanation 1 says, it is not necessary that the imitation, resemblance should be exact. Explanation 2 says, when a person causes one thing to resemble another thing, and the resemblance is such that a person might be deceived thereby. If the resemblance is such that by such resemblance one can be deceived, it shall be presumed that the contrary is proved, until the contrary is proved, that the person so causing one thing to resemblance That is, if when to resemble another thing and the resemblance is such that the person might be deceived, then it shall be presumed that he had prepared something with intention to deceive. Resemblance to practice deception, or he knew that thereby deception will thereby be practiced. So now come to provision section 489A. Counterfeiting currency notes or bank notes. Whoever counterfeits, you should understand the counterfeit meaning. Counterfeit as defined in section 25. That is counterfeit. The 28. That is counterfeit. Whoever counterfeits or knowingly performs any part of the process of counterfeit, either counterfeits or knowingly performs any process of counterfeit, any currency notes or bank notes, shall be punished with imprisonment for life. It's a very serious offense. Whoever counterfeits any currency notes or bank notes shall be punished, or makes any process of counterfeit. Not only that, whoever counterfeits or knowingly performs any part of the process of counterfeit, any part of the is about to make some process, that is any part of the process of making counterfeit of a currency notes or bank notes, shall be punished with imprisonment or a description, imprisonment with imprisonment of life, or with imprisonment for either distance for a term which makes them 10 years, and shall also be liable to fine. Explanation. For the purpose of this section, what is banknote and currency note? For the purpose section and of section 489B, C, D, and E, the expression banknote means a promissory note or engagement for the payment of money to bearer on demand, issued by any person carrying on business of banking in any part of the world. So what is banknote? The expression banknote means a promissory note, bearer promissory note. So suppose 100 rupees note is a bearer promissory note of the who bears it. That is governor, Reserve Bank governor promises to pay the bearer the particular money, particular amount of the rupee, particular amount, whoever bears that. So what is banknote? Banknote has been defined here. That is for the purpose of not only 489A, for the purpose of this section, that is 489A, 489B, 489C, and 489D, and 489E. The expression banknote means a promissory note or any engagement for the payment of money to bearer on demand. Either promissory note or any engagement, any contract or any document for the payment of money to bearer on demand, issued by any person carrying on the business of banking in any part of the world, even a dollar, that is also a banknote world, or issued by or under the authority of the state or sovereign power, that is issued by the authority of the state or sovereign power, and intended to be used as equivalent to or as a substitute for money. That is intended to, that is promissory note, or any engagement for payment of money to bearer on demand. Promissory note to payable on bearer on demand, or any engagement for payment of money to any bearer on demand, issued by any authority, any person carrying on banking business, carrying on the business of banking in any part of the world, or upon any authority that has been issued, that is promissory note issued by any authority of any state or sovereign power, and intended to be used as equivalent to or as a substitute for money. Then only that will be treated as banknote. So 489B, using a genuine, forged or counterfeit currency notes and banknotes. Whoever sells to or buys or receives from, sells to, buys, receives from any other person, or otherwise traffics, moves in or uses as genuine any forged or counterfeit currency note, counterfeit currency note, banknote, knowing or having reason to believe the same to be forged or counterfeit, that shall be punished with imprisonment for life, or with imprisonment for either distance for a term which makes them 10 years, and shall be liable to fine. Similarly, possession of Forged or counterfeit currency notes or banknotes. Banknotes, as defined, you should understand banknotes. So currency notes also, that is, what is currency notes? Currency notes, that is dictionary meaning, is to be taken into consideration. That is issued by the note. So what is that? Oh, that is whoever has in possession of any forged or counterfeit currency note or banknote, knowing or having reason to believe the same to be forged or counterfeit and intending to use the same as genuine or that it may be used as genuine shall be punished with imprisonment by either of for a term which may extend to 7 years or with fine or with both. For 1890, making or possession instrument or material for forging counterfeit. Any instrument material we possess makes is also liable for punishment. Whoever makes or performs any part of the process of making or buys or sells or disposes of or has in possession any machinery, instrument or material for the purpose of being used or knowing or having reason to believe that it is intended to be used for the forging or counterfeiting any currency notes or banknotes shall be punished with imprisonment for life or with imprisonment for either discretion or for a term which may extend to 10 years shall also be liable to fine. 489E, making or using documents resembling currency notes or banknotes. What this says? Whoever makes or causes to be made, either who makes or causes to be made, or uses for any purpose, makes, causes to be made, uses for any whatsoever, or delivers to any person, any document purport to be, or in any way resembling or so nearly resembling as to be calculated to deceive any currency notes or banknotes shall be punished with fine which may extend to 100 rupees. Whoever makes or causes to be made or uses for any purpose whatsoever or deliver to any person any document purport to be or in any way resembling or so near resembling as to be calculated to deceive any currency or banknote shall be punished with fine or which may extend to 100. Why such a small amount? Because sometimes this is used as display thing. That is, those are not actually with intention to deceive, but only resembling. So that's why it is small, is 100 rupees fine. If any person whose name appears on a document, the making of which is an offence under subsection 1. Subsection 1 refuses without lawful excuse to disclose to a police officer or being so required the name and address of the person by whom it was printed or otherwise he shall be punished with fine which may extend to 200 rupees. Who prints that? That is, sometimes in the market it is sold. So as a instrument for playing, that is by the children. So such resembling only, not deception is there. Where the name of any person appears on any document in respect of which any person is charged with an offence under subsection or any other document used or distribution in connection with that document, it may, until the contrary is be punished, be presumed that person caused the document to be made. Now, this chapter 19 of the criminal breach of contracts of service, this section 490 has been deleted. Now that has been repeated, but only 491. What is contract of service? Suppose if a person has engaged a person as his servant, another as servant, whoever that is by inducing that person causes breach of that contract, that is punishable on section 490, that is 91. Breach of contract to attain on and supply wants of helpless person. This is only breach of contract. This is a quasi contract. Suppose a helpless person is there, suppose a minor, innocent person, sometimes they are maintained by another person under a contractual obligation. Whoever being bound by lawful contract to attain on or to supply the wants of any person who by reason of youth or unsoundness of mind or of a disease or bodily weakness is helpless or incapable of providing for his own safety or of supplying his own wants, voluntarily omits to do so, shall be punished with imprisonment of either the six or a term which makes to 3 months, or with fine which may extend to 200 rupees or with. This is only one section, that is breach of contract of service during voyage or journey, that has been repealed. That is, but section 491 says, suppose a person, he has entered a contract. What for? And as per a lawful contract, he is bound to attend on or to supply the wants of any person who is, because of his young age or unsoundness of mind or disease or bodily weakness, is helpless or incapable of providing for his own safety or supplying of his own wants. If that person voluntarily omits to do so, he is also liable under civil liability, but criminal liability says, criminal law says, then in such case he shall be punished with imprisonment of either description for a term which may extend to 3 months, or with fine which may extend. Whereby being bound by lawful contract, only there is a contract, but not under law. Suppose a person neglects to maintain his child or doesn't maintain his child, then section 491 is not applicable. But suppose there is a contract. Suppose X entered a contract with Y father, who is at a far off place, or who is abroad, who is in abroad, to maintain his child or wife or diseased person or diseased father, and he has entered a contract. There must be a contract. Only then section 491 is applicable. What it says? Whoever being bound by any law, there is a lawful contract. There is a contract. What? Bound by the lawful contract? To attend on or to supply the wants of any person. To attend any person or to supply the want of any person, who by reason of his youth, or of unsoundness of mind, or of a disease or bodily weakness, is helpless or incapable of providing for his own safety, is incapable to provide his own safety, or of supplying his own wants, voluntarily omits so to do, shall be punished with imprisonment or either death for a term which may extend to 3 months, or with fine which may extend to 200 rupees. Now, this is of offences relating to marriage. You see, chapter 20 deals the offences relating to marriage. In this category, we find 493, 46. 493 says, cohabitation caused by a man deceitfully inducing a belief of lawful marriage. Every man who by deceit causes any woman who is not lawfully married to him to believe that she is lawfully married to him. A person who knows that he is not lawfully married to a woman, but by practicing deception, he causes, by deceiving, causes that woman to believe that that woman is his lawfully married wife, and then cohabits or have a sexual intercourse with him. In that belief, shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. This section is attractive when a person, knowing that the proper marriage ceremony is not performed, or knowing that he is not, that is a marriage, he are not married, but suppose he accepts simply a garland, says that thereby the marriage is complete. Because if thereby the woman is deceived, if the woman doesn't believes, and thereby lawful marriage takes place, and that person cohabits that person or that woman or sexual relation with that woman, then that is punishable with imprisonment which may extend to 10 years. 494. Marrying again during lifetime of husband or wife. During lifetime of husband. Section 494 is a very interesting section. Whoever having a husband or wife living. A person has a husband is a live or wife is a live. Marriage in any case, in which such marriage is void. The marriage, and in such case the marriage is void. This is not applicable to Mohammedans because the marriage of a Mohammedan man with a second woman, for the second time with another woman, is not void. So first thing you see, section 494 is applicable. Whoever, either husband or wife, having his spouse living, when her or his spouse living, either if a husband is wife living, or if the wife is or husband living, marriage in any case in which such marriage is void, and he marriage in such a manner that is marriage is a void by reason of its taking place during the life of such husband or wife. During the life of such husband or wife, if that marriage takes place, that marriage is void, shall be punished with imprisonment either duration for a term which may extend to 7 years, and shall also be liable to fine. Exception is there. This section does not extend to any person whose marriage with such husband or wife has been declared void by a court of competent jurisdiction. Does not extend to any person whose marriage, if that person's marriage had been declared as void by a court of competent jurisdiction, then his marriage or her marriage for the second time is not, is this, in such case 494 is not honor to any person who contracts a marriage during the life of a former husband or wife, if such husband or wife at the time of the subsequent marriage shall have been continuously absent from such person for the space of 7 years, and shall have not been heard by such person as being alive with that time, provided the person contracting such subsequent marriage shall, before such marriage takes place, inform the person with whom such marriage is contracted of the real state of facts as far as the same are with his or her knowledge. Section 494. You know, whoever marries for the second time during the life, during the without any dissolution of his marriage, without divorce, or when his or husband or wife is alive for the second time, that is applicable. But exception says this marriage, this section will not be attractive when the earlier marriage has been declared void. Second, it is very important. If a person marries for the second time, when our former husband or the former wife is not heard for 7 years, and such person is what is not for subsequent marriage shall have been continuously absent. If the former husband or the former wife is continuously absent from such person for a space of 7 years, and shall not have been heard of by such person as being alive within that time. Within that time means within that 7 years. If the first husband or the first wife is continuously absent for 7 years, and not only that, and that person has not heard that such person is alive within that 7 years, provided that the fact that the person who marries for the second time informs such fact to his second husband or second wife. What fact? That he had earlier married, his wife is continuously absent for 7 years, and or whereabout is not heard by him for the said period of 7 years. So that's why it is provided within that time, provided the person contracting such subsequent shall before such marriage takes place, before the second marriage takes place, inform the person with whom such marriage is contracted, that is the second wife or the second husband, of the real state of facts, so far as the same are with his or her knowledge. Section 495. Same offence with concealment of former marriage from person with whom subsequent marriage is contracted. Similarly, if a person had married for the first time, he concealed that first marriage and married for the second. Whoever commit the offence defined in the last preceding section, that is beginning section, having concealed from the person with whom the subsequent marriage is contracted, by concealing the first marriage, the fact of the former marriage shall be punished with imprisonment which may extend to 10 years. That person is also liable for the second time if a person is married, concealing the fact of his first marriage and that marriage has not been declared void or that there is no divorce. Then shall also, that is punishable with 10 years and shall also be fined. Then marriage ceremony fraudulently gone through without lawful marriage. Whoever dishonestly or with a fraudulent intention, dishonestly, fraudulent, causing wrongful loss, or fraudulent intention, go through the ceremony of being marriage, knowing that he is not thereby lawful. His also ceremony is undergoing, knowing that thereby he is not lawful marriage, shall be punished, which imprisonment by the decision for a term which may extend to 7 years. 497, this adultery, this in the next class we'll discuss how this law, this provision of adultery that has been declared as ultra virus by the decision of the Honorable Supreme Court. We'll discuss this section 497 and onwards. Thank you.